Hi, everyone. We'll give everyone a few moments to filter in. Welcome. I see participants are slowly filtering into the room. Great to see you all. Thank you for joining us. Hi, everyone. Okay, so hi, everyone, and welcome to CCSI's 16th Annual Speaker Series. My name is Jessie Coleman, and I am a Senior Legal Researcher at the Center. As in previous years, our speaker series is very kindly sponsored by Arnold and Porter. Today's talk marks the last instance of our series this year. You can find recordings of previous sessions on investment facilitation and on the African Continental Free Trade Area on our website. This session is also being recorded. In today's discussion, we will address progress made to date on creating investment frameworks that are grounded in human rights obligations and principles. And we'll also talk about future priorities for action at this really important intersection of human rights and investment law. We are joined by really terrific thought leaders in this field today, so we're really excited by the discussion that we're going to have. I'll turn the floor now to Kabir Douglas, Senior International Arbitration Advisor with ANP, and both a panelist and co-moderator today, to introduce today's panelists. So Kabir, over to you.
Thank you very much, Jessie. Let me just begin off by welcoming everybody. And I personally would like to note how honored and delighted I am to be here. This is a very important topic. I'm going to go forward and say that it's probably the bajillion-dollar topic, the elephant in the room, right? How do you deal with human rights and investment arbitration? If we can figure this out, I'd like to say the world will be a lot better and a happier place. But to do this, we need amazing minds. And we really, as Jessie just said, have put together a fantastic panel of experts. All of them join us at an awful time for them respectively. And this just shows their commitment to the topic and to the issue that we have. So we are grateful to all of them. I'm just going to make a very, very important clarification here. Each of these speakers' bios, if we have to do justice to them, will take us an hour. That means 3 hours. Jessie has advised me that we have 1 hour for the panel. So I'm going to do very brief introductions to each of our speakers, but look them up. They're absolutely awesome. In order of their first names, we have Jane Seruwagi Nalunga, the Executive Director of Siatani, Uganda. Jane, thank you for joining us. We have Professor Suryadev, the Chair of the UN Working Group on Business and Human Rights, and a professor at the Macquarie Law School in Sydney. And we have Professor Tara Van Ho, a Senior Lecturer at the School of Law and Human Rights Center at the University of Essex. As you can see with this very brief introduction, if we need to be talking about this topic, we have 3 ideal superstars to talk about it. Jessie, I'm going to pass the floor back to you to start the hot seat questions. Take it away, Jessie.
Thank you so much, Kabir, and for kicking us off on a lively note, as ever. So to start today's discussions, Kabir and I will pose some questions to our panelists, and we are also really eager for your questions as well. So please post those questions in the Q&A box, and we'll turn to those after initial reflections from panelists. So Surya, we'll come to you first. We are gathering today on the tails of the UN Forum on Business and Human Rights, where you convened a discussion together with Jane, Tara, and several other friends of CCSI on aligning investment treaties with human rights obligations. And that discussion really builds on work that you have driven as a member and chair of the working group on business and human rights in seeking to really make the redesign of the investment treaty system a priority issue for the business and human rights community. Could you share with us your assessment of progress made over the past 10 years in seeking to drive meaningful reform of investment governance so that these frameworks advance rather than undermine human rights? So Surya, over to you.
Thank you very much, Jessie, for the question and also for the invitations. It's really my great pleasure to be sharing some thoughts on this very topical issue. In the last 10 years or so, I think if I have to highlight the progress, I would like to focus on three aspects. First of all, there is a growing acceptance amongst the key stakeholders for the need of reform of the international investment agreements. At the same time, I would say that what this reform should mean or would mean, there is a lot of disagreement. And I think that is where the question of what is a meaningful reform, it is a subjective perspective. So if you ask the rights holders, what is meaningful for them is going to be very different if you ask states or certain states, or if you ask, let us say, a person who is sitting on the arbitration panel of these awards. So I think it's a very diverse situation. But I think almost everyone agrees that some reforms are needed because the current system is unsustainable. And that itself is a sign of progress in my view. The second is that we can see some state action in the last several years where there are signs of winds of change or winds of positive change, I would say. Whether this is because of some model bilateral investment treaty that have been drafted, whether this is India or the Netherlands or other countries, so they're progressively moving towards that. Or we see the emergence of CSR language or RBC, responsible business conduct language in the bilateral investment agreements, or in the preamble, increasing reference to sustainable development languages. All this is very weak, as I will come to later on, but I think that is still itself a progress. The other aspect of this state action is that some states have taken a position that we're going to terminate our bilateral investment agreements, whether this is India, Pakistan more recently, or some states taking the position, oh, we don't want ISDS anymore. We will create some other system of dispute resolution. The third and the final aspect of change that I would like to highlight is that at various fora, some kind of a process is going on to deal with this reform process, whether this is UNCTAD or UNCITRAL or OECD or ICED or treaty process on the business and human rights. So there are multiple things happening at different places where this question is very much on the table. Not all aspects of the reform, bits and pieces, I would say, at many places, but something or the other is definitely on the table. So I think I will stop with that. Thank you.
Thank you for that, Professor. You gave us a very good insight of these three issues looking at the past decade. And so just taking that, we're going to tweak it a little bit, ask you to pull out the magic crystal ball and tell us, looking ahead to the coming 10 years, what does meaningful progress look like in your view? And just on this point, there is this roadmap that has been launched at the forum. We'll put a link in the chat for everybody, right? This is intended to guide the next decade of business human rights, right? Will that provide us any guidance? What is your view on that? So Professor, back to you.
Thank you. So in the next 10 years, I hope the progress of reform is much more ambitious. The roadmap that you're referring to is the roadmap that the Working Group on Business and Human Rights released early, it was last month, in fact, 29th of November at the 10th UN Forum, because we completed 10 years of the UN Guiding Principles, and we are suggesting what should be done in the next 10 years. And I think on this particular issue, the guidance for this roadmap is coming from our report, which I had the pleasure of writing and presenting to the UN General Assembly in October this year. And I will invite all the people to reflect on the recommendations in the report in this brief time, let me quickly go through the 5 aspects that are very crucial in my view. First is that we need to rethink the very purpose of investment. I think states are too much obsessed with this idea of, oh, if we sign these investment agreements, they will be investment, and that is good for us. No. First of all, merely because you sign an agreement, it does not mean that investment will automatically come. Even if investment comes, it may not be good for the society entirely. It may be good for 5% of the people, or it may be good for the society in the short term, but not in the long term, right? So I think we need to look at the very purpose of the investment. And I think the sustainable development goals and the idea of climate change and renewable energy, or all these issues are going to become very, very central to this issue in my view. The second is that often we talk about that states have a right to regulate investment and investors. And the report recommends that we change this mindset, that states don't merely have a right, they have an obligation to regulate under international human rights law. So we need to shift this narrative from the right, which implies discretion, power with discretion. Now we are saying you not only have a power, you have an obligation. So you don't have the discretion to decide whether to regulate or not. And of course, so then many recommendations how that duty should be exercised. The third is, which is very, very critical, that there have to be human rights obligations. And I'm going to underline the word obligation, not responsibility, of investors. Because these investment agreements are conferring rights on investors, not merely soft rights, legally binding rights. And if we need to create this balance right, then we need to create obligations on par. The fourth is we need access to remedy for the affected communities. Now, let us be very clear. Investors are third parties to these agreements. If these third parties can get rights and access to remedy through these agreements, what about other set of third parties, which are the affected communities? So anyone who does privity of contract, because investment agreements are just contracts between two states. So if these non-parties could claim rights, what about other set of affected communities who also have rights, not under constitutional law, but under international law? So what about their rights? So I think we need to create some pathway for that. And finally, ISDS. I think you mentioned this probably this is the elephant in the room. There are attempts at various fora to save the system. But in my view, the system is beyond repair. We just need to get rid of it and create a more transparent, fair, and equitable system that can resolve disputes for all parties in a fair, equal manner. Thank you.
Fantastic points there, Professor. Let me pass it to Jesse.
Thank you so much, and really terrific points, and kick us off in a great direction. I would like to turn to Jane next. Jane, you and Sayatini lead really terrific work at various levels, global, regional, and national in this field. You have, for example, advanced campaigns around termination of investment treaties related to what Surya was flagging, that conflict with human rights obligations. And you've also supported revision of national investment laws as well, an area that I think we don't focus on enough, and national policies to align them with human rights and environmental obligations. We're really curious to know how you feel about the progress being made in this area. Are we pushing hard enough, and where do we need to do more? So over to you, Jane.
Thank you so much, Jesse, for the very kind. Thank you so much, Jesse, for the kind introduction, and also for the kind appreciation of the work we are doing. Regarding the issue of the issue of whether what we feel about the progress being made. I think it's really important to say that, you know, that there is progress being made. I can give an example from Africa as Surya has pointed out, the issue of business and human rights and the need to review the investment laws is on the table and it's being discussed. And we have seen campaigns at the multilateral level, in the WTO, government saying, no, we want space for us to be able to regulate investments. And also in my region, I have seen countries like South Africa reviewing their investment policies. In Uganda, we have also had a review, although it wasn't as extensive as we wanted it. And for the first time, I have seen countries in Africa like Uganda, Tanzania, asking countries like Netherlands to renegotiate their bilateral investment treaties. So there is progress being done, but it's not enough. We are not pushing hard enough because there are still glaring gaps in our regulatory frameworks. And the balance, when you look at our policy frameworks, the balance is tilted in favor of the investors. You find there are no protection for the people, for the communities, for the environment. And as Shira has pointed out, the obligation of states to regulate has also been constrained by provisions like ISDS, provisions like expropriation. So there is a lot we need to do. We need to push a little bit harder. Your last question was, where do we need to do more? We need to do more on all fronts. But for me, I think the most important front to work on is the issue of the mindset of our politicians, mindset of our policymakers, and of our technocrats. We need to be able to change this mindset, you know, to make sure that our policymakers appreciate the fact that FDI is not charity, you know, that FDI, you know, can't automatically provide decent jobs. Sign, like Surya has pointed out,
Jane, I think the point you were making was terrific and aligned very much with what Surya was saying.
Which have reviewed their investment treaties, getting investors. So for me, I think there is a lot of work to be done on all fronts, at national level, regional level, global level, but I'm picking the most crucial part of it, the issue of changing mindsets at national and regional levels, and also at continental level. Maybe I stop there.
Thank you so much for that, Jane. Fascinating points. These insights are very valuable. Jane, actually, in this very speaker series, I think our first session, we looked at and spoke about the protocol to the investment to the African continental FTA, right? This is going to be a ginormous agreement. The protocol, in some senses, I think is going to be covering more people and more investment than we have ever imagined. And this is our question that we'd like to ask you. You know, the negotiations are ongoing. This protocol may actually set the stage for investment policy at the continental level in Africa for some time. Now, in your view, what should this protocol look like with the view towards advancing rather than undermining human rights? What are some critical issues you would like us to think about when it comes to this protocol? We invite you to bring your futuristic ball and look into the future and make some predictions. Jane, please take it away.
Thank you so much, Kabil. That's really, really an interesting question because today the CFTA is the elephant in the room in Africa, and we have so many hopes around it, you know. So I think it's very important that the CFTA, the Africa Union, has talked about putting in place a protocol on investment, and it's going to have so many advantages for us as Africa. For me, my hopes around the protocol is that it will provide an opportunity for Africa to come up with an investment template that can be used to guide policy reviews at national level, regional level, but also at the multilateral level. Because for now, we are not clear as Africa when we talk about investment facilitation in the WTO. And you find, you know, different African countries are taking different positions at the multilateral level. And I hope also that the investment protocol will be able to take into account the different levels of development of African countries. Because if we don't do that, again, investment, human rights abuses will continue because we are at different levels of development. You know, so for me, I think the investment protocol, it should be able to balance the rights of the investors, the state, the people, and the environment, you know. So whatever they do, they need to balance that. The investment protocol should enshrine social and human rights provisions in the investment protocol and do away with the provisions that curtail the obligation of states to regulate in the public interest, such as ISDS, you have talked about that, the expropriations, those ones should go. And lastly, Kabil, I think the investment protocol should mainstream, encompass all our aspirations. For example, as Africa, we have the Africa Mining Vision, which helps us to, which are supposed anyway, to beneficiate our natural resources. And we also have, for example, the AU, the Africa Union, has come up with a guiding principles on large-based land investments. So for me, I think all those aspirations should be enshrined within the investment protocol, and we can be able to use then that protocol to review our national and regional investment regulatory frameworks. Thank you so much. But that protocol has to be really, really ambitious to help Africa. Thank you.
Thank you very much, Jane. Those were fantastic words. I'm going to pass the floor back to Jessie to ask Professor Van Ho the next hot seat question.
Thanks, Kabir. And thank you so much, Jane. I love your point about mainstreaming aspirations into the protocol. I think it's a really terrific objective for us all to have. And I know that a lot of eyes are on what's happening around the protocol right now. So turning to Tara, your scholarship and thought leadership in this space is really well known among both investment and human rights lawyers and scholars and advocates. And you have made clear in your work the deep and systemic failures of the system and of ISDS in particular, and how the current iteration of the regime really undermines human rights, exacerbates challenges faced in transitional justice contexts, and also really works against the public interest in moments of really deep crisis, whether it's COVID or the intensifying climate crisis. Proponents of ISDS often argue that the mechanism is necessary because domestic courts are, according to advocates of ISDS, inadequate. and because investment treaties and ISDS promote investment flows, according to those advocates of ISDS. So what do you say to those who advocate for this system on this basis?
Thanks, Jesse, and thanks to you and Kabir for today's session. It's really enjoyable to be with all of you and to be with my friends Suri and Jane again as well. So I want to start with where I agree with those apologists for investment law, and that's that we should be skeptical of domestic legislatures and judiciaries. I'm a human rights lawyer at my heart. That means that I am generally antagonistic towards state action. I am generally questioning whether or not they're acting in good faith, whether or not they've hit the right balance. That's our role as human rights lawyers. And there shouldn't really be a human rights lawyer in the world who goes, yay, states are the good guys. So I'm on board with being skeptical. But now for where I disagree. And that's that first about where the concern should really lie. Investment lawyers tend to talk about this while casting aspersions on developing states, right? We need to have bilateral investment treaties, otherwise people won't go into Uganda because you can't trust the Ugandan courts, or into Kenya because you can't trust the Kenyan courts, or into India. But I am American, if you didn't pick up on the accent, and the US is probably one of the most chaotic places in the world when it comes to governance. We know that, right? We're currently in the situation of the US Supreme Court reviewing 40 years of its own jurisprudence around women's rights to control their own bodily autonomy. And the notion that there are some states that are chaotic in legislature and other states that can govern themselves appropriately is deeply concerning, but that's the reality that investment law embraces and perpetuates. In the Methanex versus United States Court or Tribunal decision, we saw that ISDS investment arbitrators were willing to allow for chaotic legislative processes in the US, that was expected. So there is a recognition that at times that's just part of the democratic process. And anytime that you enter into a state, you need to be expecting a little bit of chaos, a little bit of change, a little bit of alterations to your expectations. And so it's not actually, I find, it's not that the domestic courts are inadequate, it's that states, or that investment lawyers are afraid of certain domestic courts. And those domestic courts tend to be from developing states. And if that's the road we're going to go down, if that's the narrative that we're going to embrace, then we need to call it what it is, which is it is racist, it's colonialist, it has been disproven time and time again. And it's deeply problematic that that's where we're going to allow our justifications for the system to stem from. The second disagreement out of three, by the way, is the notion that investment agreements lead to investment flows, and that's good for society. And Suri has well covered that, so I'm not going to go over his points again. But I will say that the burden of proof for justifying bilateral investment treaties, for justifying ISDS, are on those who want us to embrace it, not on those of us who think the system itself is flawed. If you want us to cede sovereignty to an arbitral panel that the plaintiff gets to choose one of the arbitrators for, then justifying that rests on you. And the investment side, the pro-investment law side, hasn't actually carried that burden. They don't have the data points to support the notion that this supports investment flows, that this is good for society, that this is good for our economies. So on that, I think they fall as well. And then the final disagreement is what we do with our legitimate distrust. Because as I said, legitimately distrust states. I agree with that. But the answer to that distrust is not to exempt the richest within a society or the richest and most elite within our global society from the chaos of the democratic process, from the chaos of a legislative or judicial process that is responsive to developments in the field, to developments in science, to developments in our knowledge, to developments in our value system. The notion that I will be subjected to whatever the US Supreme Court decides about 40 years of its own jurisprudence but Shell isn't subjected to Nigeria's legislature figuring out that actually dumping large amounts of oil in the Niger Delta probably shouldn't happen. Or the Colombian government deciding that actually we need to protect the highlands. The notion that these elite actors within our society should be exempted from what the rest of us go through when it comes to subjecting ourselves to the governance of a state, that's where I have a problem. The answer to that is not ISDS, it's not investment law. The answer to that is a couple of things. The first is that we need to demand stronger democratic, legislative, and judicial standards for everyone, right? If your concern is that there's going to be racial discrimination or national discrimination based off of national identity, if your concern is that people could be subjected to arbitrary treatment, if your concern is that people could be subjected to arbitrary trials, enhance those systems, demand that accountability. But don't do it for some, do it for everyone. And the second part of that is have a stronger human rights system, right? The problem here is that ISDS is so powerful that a government in in South America who's subjected to the Inter-American Court of Human Rights can't even get the case heard before the Inter-American system before ISDS has decided what the balance of its rights and responsibilities are. And that balance has yet to favor non-investors. It has yet to really favor the state's human rights responsibilities, whether that's Argentina with water or Colombia with the environmental protections. What we're seeing is sort of a stranglehold on the human rights systems and a degrading of that, when what we should be seeing is a strengthening of that. Human rights are actually developed, the legal framework for human rights has been developed with a recognition that my rights as an individual sit in the broader community sphere. And they sit in tension at times with your rights, Jesse, or Surya's rights. And that the law itself has to have space to balance those rights. It has to have space to recognize that I'm allowed to have free speech, but I'm not allowed to defame you. I'm allowed to have free speech, but I'm not allowed to threaten to murder you. And so there is already within human rights law, whether it's through our limitations clauses on certain rights or through the decision that certain rights are non-derogable, or through the existence of the derogation clauses. There is already within human rights law a sort of sense of balance between the individual and the community, between my rights and the needs and obligations of the state as a whole. And so if we invest in those infrastructures, if we build that up, then we provide the mechanism for investors to claim and complain appropriately and legitimately for abuses by domestic legislatures and judiciaries, without actually providing investment law this stranglehold on the state that it currently exercises.
Thank you so much, Tara. Really, really meaningful, thought-provoking points. I'll turn it over to Kabir.
Thank you, Jesse. And thank you, Professor. There was so many interesting insights. You know, there was a historical perspective, a sociological perspective, there's an empirical perspective. So thank you for sharing those. I'm going to slightly turn gears to a very key development happening, I'm going to say in the human rights arena, but I think it's more appropriate to say, I think in international law at large, right? There's the negotiations on this legally binding instrument to regulate the conduct of transnational corporations and business enterprises. And I think this is remarkable, just considering, you know, first principles in international law, right? The states and, you know, human beings have these human rights, but we're going to stop when it comes to macro questions. So it's fascinating. I just want to contrast this from the reality we have seen in many cases in the ISDS space, right? Where you do see that property rights or investor rights or BIT rights tend to get a priority either expressly or indirectly over human rights. And this is the question. While we see this key development, we want you to pull the crystal ball out and tell us, To what extent might you see some of these concerns, some of these tensions that have permeated the intersection of human rights and investment for decades really enter into this new legally binding instrument? I know there's a lot there, but we'd love to hear what you have to say.
Thank you, Kabir. Yeah, so the treaty itself, I think, is a wonderful development. I'm in favor of the treaty. I think resting our hopes that the treaty will be able to solve this tension is dangerous. Let's start with the fact that the treaty remains a state-centric treaty. It has obligations on the state. It doesn't have obligations directly on businesses. So it still has that sort of historical centrist approach, state-centrist approach to international law embedded within it. I also here am going to, I feel like I'm critiquing my home state a lot right before I go home. So I'm a little nervous about that, but I'm just going to keep diving into that. There has also been a recent, much more worrying trend for me, which is this effort to try to bring the US into the discussions around the treaty. And I'm going to say here why I think that it's really dangerous to do that, is that the US has historically engaged in watering down a lot of human rights treaties, whether we're talking about, I mean, I think the Rome Statute on the International Criminal Court is the prime example of that. In this sort of vague promise that the US will go along with these international legal developments, and then it never does. So this effort to bring the US to the table of the Business and Human Rights Treaty, I think the US is not going to ratify this treaty. It's not going to ratify this treaty in my lifetime. And I think that I have at least another 40 years ahead of me, I hope. So watering down the treaty to bring the US to the table, moving towards a framework convention instead of what we have now, I think is a movement of human rights counter diplomacy. And I think that we need to be really skeptical about it. And what it does also is prolong what is already a long timeline in my mind as to when the treaty, the Business and Human Rights Treaty, will be ready. I think we are 5 years before states are willing to open the treaty up for signature and ratification. I think getting enough states to ratify it to have the treaty enter into force is another 5 or 10 years. So when you look at that timeline, relying on the treaty is problematic. The treaty does have a clause requiring states to ensure that their bilateral investment treaties are interpreted in a way that complies with their human rights obligations and with the obligations within the Business and Human Rights Treaty. That's really lovely language. I am in favor of that clause. That clause will do absolutely nothing to address the fundamental principles and problems that we're talking about today. And I know that because we just had Eco Oro versus Colombia decided for us. And if you want to talk about the clearest acknowledgement by investment arbitrators that they have absolutely no interest in normal treaty interpretation rules, in normal standards of international law, in caring about human rights and caring about environmental protections, Eco Oro is that statement. Eco Oro is the statement by the investment community that the rest of the world doesn't really matter to them. And I say that because at the core, so for those of you who aren't familiar with Eco Oro versus Colombia, the underpinning developments of this started in 2007 when the Colombian legislature introduced a law that would change and protect certain levels of its highlands, and particularly fragile ecological and environmental areas. At the time, Colombia and Canada didn't have an investment agreement at all. When they eventually adopted one, they made it explicit that those two states could adopt environmental protections, that was allowable under this free trade agreement. Now, the fact that you had to even have that as a provision is itself problematic. But second, when you're talking about what the provision says, by making something allowable, by being so explicit that states are allowed to do this, what the states were saying is that adopting environmental protections cannot be an internationally wrongful act, meaning that when they adopt those provisions, there's no reparations to be paid, there's no compensation to be paid. What did the ECO-ORA arbitration panel decide? Yes, Colombia is allowed to adopt environmental protections, but they still owe reparations. That, by the way, is like such a fundamentally basic part of international law that I cover within the first 2 weeks of my undergraduate public international law class. And I would fail my undergraduate public international law students for reaching the conclusion that the tribunal did, because you cannot order reparations for something that isn't unlawful. And by the way, I say that I would fail them, and I want to be clear about this because of how problematic that decision is. In the US and the UK, the most that you can fail is a 0. In Denmark, for a written piece of submission, you can fail at a -3. If you are so fundamentally wrong that 0 isn't enough to say how wrong you are, you can actually go down to a -3. And I would have, had this been submitted to me in Denmark, given this a -3. That's how fundamentally flawed the decision's understanding of the basic parts of international law is. So to ask a tribunal, with that as our history, with that as our understanding of where investment arbitrators can or are willing to sit when it comes to basic issues of statutory or treaty law, asking to fix that through a new treaty, I just have no faith that that's going to be the answer. And that's why I come back to what Surya said at the beginning, which is that this system as it is cannot continue to operate. If we want to fix the tensions between investment law and human rights, we have to develop a new approach, and ISDS is not it. So that's it.
Fantastic points there. I would hate to be your student with the -3, but as they say, sometimes you work very hard to earn the -3. So thank you for sharing that.
I should say I've never actually had to give anybody a -3 because my students would not have made that basic of a mistake.
Yeah. Well said there. Jesse, back to you.
Thanks, Kabir. Thanks, Tara. I think ISDS is not it might be a good tagline for t-shirts that we all might be wearing at some point in the future. Okay, so we have a lot of questions. We're going to try and group several of them together, and I'm actually going to also ask Kabir to jump in response to any of these questions that Kabir would like to jump in response to. So several participants have asked about the future of ISDS, which is obviously a hot topic in this conversation. ISDS is not it, is the tagline, I think, and the theme of some of our discussion. If we're moving away from ISDS, what replaces that is the general gist of some of the questions. We know there are several existing alternatives to ISDS. Are there also emerging alternatives that we have yet to think about? What are panelists' views about the Multilateral Investment Court, the MIC, which is being discussed in several fora. I'll also mention a couple of other questions, and then we'll turn to you all to respond to one or more of the questions that you would like to respond to. Several participants are also asking specifically about developments across the African continent and with respect to the AFCFTA. So do we see potential for the recommendations in the working group report? And Surya spoke to, for example, to influence the negotiation on the protocol or to influence changes to national investment laws. So it'd be great to get Surya and Jane's perspective on that in particular. One participant also asks if panelists could comment on how these two fields of investment and human rights law, which are sometimes considered distinct, intersect with evolving norms of sustainability. So maybe we'll start with those questions, and I'll come to Kabir first to see if you want to comment on any of that, and then we'll turn to Surya, Jane, and Tara.
Thank you, Jesse. I'll keep this very brief because we should hear these awesome panelists speak. Where you started off with regard to alternatives and where is ISDS headed, I just do want to acknowledge something, and this is what the Working Group 3 is doing, which for me at least raises very serious concerns. because that process is going to take 10 years to complete. Now, it is counterintuitive because the mandate for the working group has apparently been given by states. But the mandate given in the working group has been only to look at procedure and not at substance. To borrow Professor Van Ho's comment, a first-year law student will tell you this, that procedure and substance often intertwine. And it's not that ISDS just has problems on process. They're very significant substantive problems, especially in the human rights arena. This is the risk we have. After 10 years of time and expense getting everybody to either Vienna or New York, well, now on the internet, but till recently this was in person, it's going to be hard to want to reopen the box for reform, because a very standard response has been there, done that. So I'm looking at this as potentially a process that is going to only affirm the structural issues that we have. I can speak more, but I really think we will benefit from hearing this awesome panel. So I'm going to shut up and pass the floor to our panelists.
Great, thanks, Kabir. Surya, could we come to you next?
Thanks. Thanks for these excellent questions. I think we need much more time to respond adequately, but let me start where Kabir stopped. That is a real risk, that there will be symbolic reforms. And I think my reading of the mandate of the Working Group 3 is that it was not meant to be limited to the procedural aspects. That has been the interpretation, that it is limited to procedural. And I would say that is a misinterpretation of the mandate, in fact. And I think that raises questions about the vested interests who are at play and who are driving this agenda. So they're trying to go for cosmetic changes and perhaps entrench the system further. And I think that is definitely a matter of concern for me. There was a question about multilateral investment court as well. And I think my response would be, we should not be obsessed with ISDS versus MIC. The key question we should be considering is that whether the challenges, the defects that we have currently, are they going to be inherited by an alternative body or not? Will this MIC be hearing cases filed by affected communities or not? Who will be the judges? Who will appoint them? Who will fund this, right? So I think those are the fundamental questions. Will there be an appeal system, right? Will there be human rights experts? Because part of the problem is that these are typical arbitrators who have a different mindset. And there was a question about the philosophies and mindset. Yes, that is, we are fighting here. The mindset and the methodologies are different. But if there is a conflict, it is the human rights methodology and the mindset that should prevail, not the investment one. And I think I will stop at that for now. Thank you.
Great, thank you, Surya. I come to Jane next for your thoughts on some of these questions around future of ISDS, what existing alternatives or future alternatives might replace the system. Any thoughts on the MIC and the Multilateral Investment Court, and also specifically thoughts on whether some of the recommendations that Surya flagged at the outset might influence the discussions around the protocol on investment to the AFCFTA and also developments at the national level across the continent.
Okay, thank you so much, Jesse. And thank you so much for the questions which came in and the opinions. I will start with the issue regarding the CFTA protocol on the continent. And like I said, it's really a very important topic.
Jane, forgive me, I think we may have lost you.
Jane, if you can hear us, we've lost your audio for now. but we could suggest that perhaps you could post some reflections in the chat if you can hear us, and then we can circle back to you and try again for final reflections in a few minutes. But in the meantime, maybe Tara, could we come to you?
Of course. So on the question of alternatives, particularly when it comes to multilateral investment court, the definition of insanity is doing the same thing over and over again and expecting different results. Replicating bad structures is going to result in bad outcomes. It doesn't matter what you do to make it look prettier. And so for me, my questions about the multilateral investment court are the same as Surya's. Who's going to be sitting on it? Because if we're talking about appointing the same arbitrators who've been on ISDS panels for the last 20 years and now making them judges on the multilateral investment court, they haven't shown themselves to be responsible yet. So why are we going to trust them with more responsibility in the future? And I realize that I'm painting with a very broad brush, and everyone is going to say, oh, but there are exceptions. And I am happy to recognize some of those exceptions. Philippe Sands, brilliant exception to the rule. But I'm not going to work off of the basis or the assumption that the exceptions are going to win on this case. I think the rule is going to win. And so in that situation, having the multilateral investment court doesn't solve any of the tensions that we're talking about. So when it comes to what should replace it, I go back to what Surya and I and Jane have largely said over the last couple of weeks, which is the same system that the rest of us are subjected to. Like there doesn't need to be a special privilege system for investment law. And the idea that there does need to be is based off of this assumption that human rights is somehow dirty and political, and economics and investment is somehow clean and apolitical and easy and objective and good for society. And that dichotomy it has no foundation to it. It's not based in reality. So let's stop buying into that, because it's just a lie. The next thing I would say about reforming the system is there's a serious question about who should be leading these discussions around the reform. Where should these ideas be generated from? And with all due respect to UNCITRAL, with all due respect to the OECD, I don't think the people who have been benefiting from the existing system are the ones to be leading its reform. And so I think if we're going to talk about alternatives, let's be serious about those alternatives and let's get different people to the leadership of these fora.
Great, thank you very, very much, Tara. So we are coming up to the end of our time together. So before we move to final reflections, I just want to check whether Jane, your audio might be cooperating a little bit better than it was previously, and we could come to you for quick responses to these questions before we move to final reflections.
I'm so sorry, Jessie, participants.
No,
I'm having challenges with my my network. Maybe I just have is on the alternatives, and I agree with Tara. She's saying, they can't be, the ISDS can't be reformed. We have to start afresh. And starting where we can start from, like Tara said, is not from the people who are benefiting, but from the people who are affected. So that's why, for me, I think it's really important that alternatives are generated from below at national level and at regional level. And for me, we still have some for our governments to, and maybe what I also wanted to flag out is the fact that at the moment, we don't have a multilateral investment treaty in the WTO. So we don't have a binding multilateral treaty there. Pace for us to be able to have alternatives at national and regional level and also at continental level.
Great, thank you so much, Jane. So we will move to final reflections from our panelists now before we wrap up. So I will start again with Surya. We'd love to hear any final thoughts or reflections from you in 1 minute, if that's possible. And then I'll turn to Tara and Jane again, and then we'll wrap up.
Thanks. I think my reflections are very simple. We are dealing with fundamental structural problems with the international economic order. International investment regime is part of that. It is not an accident that people in the global south are having poor internet, or they are not able to have access to vaccines. This is not an accident. This is a design of the system. So unless we wake up and critically understand the root causes, we cannot fix those structural challenges. Otherwise, we are just trying to do symbolic, superficial. We are trying to save a rotten system, basically. Let me put it this way. And I think it is unfortunate if we keep on pretending to do that. Thank you.
Thank you very much, Surya. Tara?
Yeah, my final reflections are very similar to Surya, perhaps unsurprisingly to either of us. I think that we need to have a radical rethinking of our current approach to the relationship between investment law and international economic law more generally, and human rights. And I think the current system has, by its design, exacerbated some of the underlying conditions and structural realities that are facilitating climate change, that are facilitating the pandemic. And if we want to get serious about that, the answers to that don't lie within the current system. They lie within human rights law, they lie within environmental law, and they lie in more robust responses than either of those two regimes currently offer either. So we need a real radical rethinking. And I think what Jane said about having leadership from below, I think that's the right answer.
Great, thank you, Tara. And Jane, final thoughts from you before we wrap up.
Thank you so much, Jessie. I do believe that the Global South has a key role to play in pushing for changes in the international investment regime, and they can be able to do it. And I have seen the Global South doing it in the WTO. So for me, I hope they can continue pushing for the changes, those changes in the international investment regime. Thank you.
Thank you so much, Jane. Kabir, did you want to add any final comments?
I don't have anything to add because I think I am largely in agreement with everything that has been said. I just add this perspective as somebody who is in the system as a practitioner. I've been here now for over a decade. And I do think that we are never, under the existing rules of the game, going to be effectively able to integrate human rights with investment arbitration. They're just fundamental differences. I just wanted to put that perspective in that, I have really tried to think long and hard. And Jessie, you and I know this because our conventional wisdom was tell states, make your treaties long, put everything in. But now we're told tribunals will do legal gymnastics to avoid that. We heard the discussion from Professor Van Ho on the Echo Oro case. I mean, it just looks like you can do everything that you are required to do and still get a thumbs down, So I just end that we really do need to think how we may want to rethink investment policy going forward.
Yes, could not agree more, and so grateful for all the insights and really meaningful conversation and discussion that we've had today. So we've reached the end of our session today. We did not get to all of the questions, the really great questions and comments that were shared by participants, but we really look forward to continuing to engage with you all on this topic, which is a topic of significant interest to the Center and obviously everyone who has joined us today. I'd really like to thank our panelists again for taking the time to join us for this really thought-provoking discussion. Thanks to Kabir for co-moderating this session and also joining as a speaker, to AMP for their sponsorship of this series, to Nancy Saporin, who coordinates this series every year, and also to all of you who participated. Recording of this session will be posted on our website in the coming days. Thank you all very much, and please do take care. Bye-bye.
Bye, and thanks everyone.
Bye-bye.